Sign language interpreter board meeting is now called to order, starting at 10:02 a.m. on January 4th, 2024. This is an in-person and virtual over Zoom meeting. This will be recorded, and the recording will be uploaded online and made accessible to the public. Anyone who plans to watch online and join virtually, please have your audio and video off throughout the duration of the meeting until you're called to provide public comment. Those interested in providing public comment and feedback during that portion, if you're called, will be during that time. I'm Jack Ludwig. We have Audrey Ramirez Loudenbach. Al is late to the meeting today. We have Mish Katik, Colleen Bayer, Tammy Adams, Eric Crook. Everyone is present except Al, who will arrive shortly. Now, members, before you speak, please use your last name to introduce yourself. There is no chat feature on the Zoom meeting. If you would like to make public comment, you need to sign in person or email Carrie Edwards at carrie.edwards@oha.oregon.gov. And you can provide your first and last name, please, when you do that. Please use appropriate language during the proceedings of the board meeting while we conduct business. Now I will be officially calling us to order. Before we proceed with the agenda, I did want to make a statement. Do you mind holding this for me? Great. As the president of the Oregon Association of the Deaf, I am compelled to address the concerns raised by some interpreters about the potential impact of House Bill 2696 on their profession. While I acknowledge your apprehensions, I must highlight a broader, more pressing issue: the ongoing challenges faced by the deaf community, not only in Oregon, but nationwide.
So as that would fall under a personal expression or a statement from the association under other board business. But the public meeting has the agenda set, and we should follow the subjects on the agenda, and then that's something you could address from your personal perspective and your role under other board business.
One moment, we need to make that accessible in ASL. Colleen's asking, Heather, could you please repeat what you just shared?
Yes, this is Heather, and with the public meeting, that would fit under other board business as a subject matter on the agenda, where board members can raise issues and express personal opinions or opinions from their associations, but that should go under other board business as a separate item.
That's fine. Okay, thank you. Eric Crook says, I have a question. My name is Eric. Colleen, so make sure you introduce yourself. Thank you, Colleen. We will be using last names. So Crook, do you mind if we go on a first name basis? Jack is saying first name is fine. Yes. I didn't mean to say last name. I meant to say your name. Address yourself using your first name. Okay, now we will be reviewing the rulemaking process. We proceed, Bob? Okay. Who wants to start with that?
It's gonna be me, I'm just trying to share my screen.
Okay.
No.
No.
You just said if you want to, it's not on.
So we're picking up. So we're picking up where we left off yesterday, and the question was posed, this is Bob, of approving the agenda.
Yes, I'll go ahead and start with that. Oh, that's not on the agenda. Okay, do we approve the agenda?
This is Heather. So you'd approved the agenda yesterday, and so you don't necessarily need to. But if you would like to, you're more than welcome.
Okay, so it's already approved, we can go ahead and get started. I just wanted to make sure because it wasn't listed here, just wanted to double check. Great, okay. So we will continue the discussion from yesterday. I believe Mish was making a comment. Colleen is saying, right, we were talking about the additional fees for the legal license because there's general, legal, SCL fees for all of those. That's what we were talking about yesterday. Colleen's still speaking. Let me find where I was in my papers. This is Colleen. I don't remember exactly where I left off, but my main concern is that the requirement to have separate licenses is that HLO should have one endorsement or whichever language you prefer to use to recognize one license. I'm going a little off topic, but the cost for licensure to be $200, I think that's misleading. I think it would probably be around 80 because you have to hold 3 or 4 different licenses. So I want to know about the supervisory and the general license. Can you add a specialty to one of those licenses so that you don't have to maintain 3 separate licenses, paperwork and fees for all of those? I would rather them be combined into one fee. And that's all inclusive. And that includes all the qualifications into one instead of 3. Is that where I left off? Is that right? I was just giving a thumbs up. Okay, that was my main concern, if that's what you remember, Mish. And then my other concern was for those of us who already hold the specialized legal certification, we already are responsible in paying other state courts and agency fees in order to hold our legal certifications and licenses there. And I don't want to have to pay twice for the same type of work. It should just be additional with no extra charge. Jackson, anyone want to add to that discussion? Audrey, go ahead. I think I have two clarifying questions. One related to the history of the legislature and how the law was written. Why can't other legally required licenses or educational laws about interpreters be followed that are already set, because we already have a precedence? Is there a way to merge those in some way into the HLO process? I understand that there's an obligation and authority to monitor and maintain that with the different classes, but I'm wondering if there's any way that we can merge those together. But I don't understand the history of why there's been all these additions, all these extra layers of qualifications and licenses and such for the different state offices. Does that make sense? That's my first question. And then my second question is about the rulemaking process discussion, which we're engaging in right now. My understanding is that for the temporary licenses, there would be no penalty. We decided upon a waiver for that, but why are we still discussing the criteria for those temporary licenses when there's no authority to enforce them? Sammy, go ahead.
This is Sammy. So a couple of things. The way the bill is structured is it has 6 specific licenses. And so the legislature said, board, we're giving you 6 different licenses to set criteria. Now, how you want to set that criteria is up to you. You want to say one, if you're a medical, like if you want your medical license, the law says you have to have a generalist or provisional. We only can work with what the legislature gave us. We can't work outside of that. And that's the first thing. But you could set a standard that the medical license is, you have to have the same things that you have for the registry and Office of Equity Inclusion. You could make that the standard, like I think that's what you said. So you just make it level. You can do that. It's very broad of what the requirements are that the board can set. So that's up to you guys to do. So the waiver is HLO, where we have discretion to, whether you do it, you're better at this. Way better.
Yes, go ahead, Heather. Informing the interpreters, when Jack points to an individual in the room, we will just say their names.
Thank you. So the limited enforcement waiver is HLO exercising its discretion to not impose discipline, even though the law requires you to be licensed. That's what the law requires. And so HLO can't change that because that's in statute. That's what the law requires. So if people are not following that law and then provide services without a license, HLO, given the circumstances, has decided to not impose discipline for that limited circumstance. So HLO can't say you don't have to be licensed, because you do have to be licensed because the statutes say that, that's the law. But it is on the back side of that, if people can choose to be licensed and follow the law, or they can make that choice and to not have a license. And HLO would, in say that we're not going to discipline you up until the limited enforcement waiver ends in June, to not impose discipline for that narrow circumstance. So they're two different things, although I understand how they're confusing.
Audrey? Thank you. So I guess my question for everyone here, is it really worth our time to go into the rules about the temporary licenses, knowing that information that was just shared? Colleen? Colleen here. Getting better at it. Honestly, analyzing and talking about the temporary licenses and the option to discuss permanent rulings, I could give time and attention on the permanent rulings. Temporary, I can let that go. Is that clear? So if we are gonna focus on the temporary part, then so be it. Good? There's a hand raised. Sammy?
I think what we were asking is take the temporary rules to be written and how should we move forward to get from rules? So using that as your kind of your draft, maybe you hate it, you start all the way over. Or maybe you like a little, but you don't like it this much. So that was just starting as a draft, but we can start over, it's up to you guys.
Jack here. Can I ask a question and make a comment as the chair? Sammy nodding her head. Okay, I just wanted to make sure that as the chair, let me go ahead and get on camera first. Okay, so question for you. Just lost it. Oh, so are you saying that the temporary rules, as we adjust them, the temporary licenses would be based on the rough draft of the temporary rulings that would then become permanent rulings? Is that what I'm understanding? I'm not sure if my question is clear.
I'm not, no. Yeah, go ahead.
This is Heather. Let me see if I can answer the question. So I think the time on the agenda.
Sorry.
So this is Heather. And I'm going to see if I can answer that question to see if it's helpful. So I think the time on the agenda was one to relay to you, or the agenda that we started on yesterday was time to relay to the information that HLOs heard in relation to public feedback on the temporary rules. And so then the HLO wanted to also gather your feedback, maybe things that you had heard, and trying to understand whether, are there problems with those temporary rules? What are those problems? What is the general sense of those? And also just make sure we're all talking on the same page. But then in addition to that, for like today's agenda, moving towards permanent rules, you could use the temporary rules as a template, and the information that has been gathered from the public and would be gathered from the board today could then be used to create that first draft of permanent rules to build off of for the round and for the future. So it was to kind of those two things is, are there problems that are so big right now that, oh my gosh, we're looking at real problems here, or can this draft be used for something that we can go for permanent, or should we just scrap it all? I think, is that right, Sammy?
Yep.
Audrey? So then we can decide whether or not that's worth our time or not. But personally, I think that the RAC and who is selected for that group would be the best fit for them to create the draft. I feel like if we take on someone we've already written for the temporary licenses, then that would be up to them to kind of decide that process for themselves. Interpreter switch. Okay, Mish, go ahead.
This is Mish. I agree, the RAC can have those discussions and bring them to us, and we can take a more in-depth look at that time. Right now, we have some exemptions that I think are really important to document and to protect cultural brokers, as well as interpreting students who are involved in internships. Those two groups are really important that we do, put those down as part of the rule-making process. And we don't want to forget to protect those groups. Audrey, this is Jack. Audrey, do you want to add? Go ahead, Audrey. And this is Audrey. Sorry, I'm making a lot of comments here. So I guess my question is, do we have the authority to change the provisional license now as it's written? I mean, to suggest, like you just made suggestions of a couple things we could add it to the rules. Oh, this is saying the rules. Okay, this is Audrey. So the rules can be adjusted for the temporary license. So this time,
Is that what you're asking? Well, you have to file a new temporary rule. You can amend the temporary rule, yes. Is that what you're asking?
Jack is looking around. All right, so do we need to make a motion on that then?
Motion.
A motion to amend the rules if we want to amend them. Is that something we would need to make a motion on?
So this is Heather. I think that the first question would be is there something in the temporary rules that you would want to see amended? And why? Is there such a big problem with the temporary rules that it should be fixed by amendment or by an extenuating circumstance or something else that we could find in the law to fix? Maybe there's barrier or problem that you see right now that needs to be adjusted. But that was part of the information gathering, so that if there is that type of thing out there, then it can be assessed as to what to do next and what options are available. There may not be an option, or there may be an option, but we don't know until HOL has the information about what might be wrong with the rules and feedback that you have. I would suggest not doing a motion until there's more of that substantive information about what an amendment might look like, or whether there's a different option to move forward to correct any concerns that are problematic. As discussed yesterday, the difference between temporary and permanent rules is that temporary rules need to meet a certain standard. And so that would also need to be addressed as to whether an amendment would meet the standard for filing a temporary rule, or whether that's something that has to be addressed in permanent after the rulemaking process. So there's a lot of things to consider. And so having that open conversation now of gathering information would then help determine what would be the next step.
Audrey, go ahead. This is Jen. This is Audrey. I just want to add to Mish's comment, the information around student interpreters, but some, frustrations that have come up, that, we have plans to place interpreters into, students into specific internship sites, for example, K through 12 sites or other sites where they are being supervised by interpreters, by working interpreters. But right now with the licensure issues that have come up, we're not sure what to do with those student interpreters if we need them to, pass some sort of test in order to pass them for the curriculum. We have a specific timeline that they need to complete a practicum, they need to complete field experience within our program. And so right now we feel a little stuck with what to do with these students, and we don't have enough time for them to be able to, access those internships and everything that they need with getting this professional license. So we're not sure how. I would suggest making an amendment specifically for students within programs that will be working in those kind of supervised settings that we just described.
So just to clarify,
This is Jack, yeah.
just to clarify, they don't need the provisionals, is that the problem that we need to overcome? Okay. Would they meet the requirements in the next 6 months through the waiver, or they need more time? Do you have an ish 2 years, 3 years, 5 years?
Yeah.
5 years? And then they could be the provisional? Or they jump in over provisional? Because they only need 3 years experience to.
Jack, go ahead, Mish. Mish, go ahead. Sorry, this is Mish. So Sammy just asked about the timeline for student interpreters to become licensed interpreters. So typically after graduating, students need about 3 to 5 years of experience to become generally licensed, what we would call generally licensed currently. And that's average. Some students require more time. I would say most, the fastest students would say it would be a minimum of 1 year after they graduate that they would be able to get a provisional license. So that would be 18 months from now, because they would graduate, in 6 months from that year. So I want to just emphasize the problem then is the reason that we're asking for an amendment to the waiver is that, for example, Western Oregon University and PCC have curriculum requirements where students must do internships or they cannot graduate during their program. So students will be interpreting, they are actually interpreting during those internships, which should start immediately, but right now it would be illegal. So even though HLO says there will be no enforcement for the next 6 months, but that's really not good enough for PCC and WU to feel like we're going to train our students. But we need something that says students can interpret on internships with, and other working interpreters supervising them. Otherwise, that's that's for state colleges. So we want to protect the college, we also want to protect the students as well. Thank you. Yes, Sammy.
This could be a temporary rule, and then it would also probably be going forward. Like, this would always be a problem.
This is Jack. Okay, does anyone else want to add to the discussion? Eric. I have a similar concern for rural interpreters as well, or people in rural settings. Often in my area in Southern Oregon, there are no interpreter programs nearby. So we often have people from the community who have, maybe they're working alongside certified interpreters and they're practicing and essentially learning from those certified interpreters. on the job. So they're actually interpreting. And with the law currently, it says that those newer interpreters are not able to get that exposure. They might be the right fit, but for us, like in Southern Oregon, if, then they basically would be required to move to another part of the state for 2 years and then come back after they get that training. So right now it's blocking those community interpreters from getting any kind of exposure on the job. They'll be, punished in a sense for trying to get that education on the job. So I don't know if there's any kind of amendment or something that can be included within that supervisory role, something like that. But for the provisional license, it really excludes that group of interpreters. So that's one concern that I have about how our rural communities will be affected and the lack of access to training in those areas. Thank you. This is Jackson.
This is Sam. Do these people in the rural areas, do they have access to somebody to train them on site? Like, how are they doing it now? And is there a way you would do lower, at least what is in the temporary rule for the provisional, lower the standard so they did meet it? And then supervision is very broad. You guys can determine how that looks on site, off site, look at it once a month. I'm the board to decide that. But if you want to lower, say the provisional, so they do meet the requirements to be licensed, and then however they do the supervision. That makes sense.
This is Jack. Eric, does that make sense? Yeah. Go ahead, Eric.
Yeah.
So your question, how are they doing it currently? Sometimes maybe that person is a CODA, so they grew up signing with deaf parents. And so maybe they take the EIPA, maybe a 3.5. There is the 3.5 requirement, but they might get less than that, for example. So somebody like that, currently that person would be teaming with somebody who did score above that 3.5 requirement and who's considered, EFBA certified. So they're working together and helping them develop those skills. So that's how we grow interpreters in the rural communities. We don't have a formal education process in those areas, so we rely on workshops, rely on online programs. We do have a few official mentors that get matched up with those interpreters to help them develop their skills up, but it's not a formal education process. So that's one of the barriers for us in rural communities. Thank you.
Nope.
This is Jack. Thank you, Eric.
Nope.
Heather?
So this is Heather. So if we look at the provisional license requirements, which is on page 9 and 10. Specifically on 10. If you look at section 6 of that rule, where they have to attest to holding a credential, are there any of those credential requirements that could be lowered that they meet? Or is there a different credential that these individuals would have, or is it a situation where these individuals would not just have any credential?
Okay, go ahead.
So my question is that on page 10 with the provisional requirements under subsection 6, and it has such as EIPA secondary PSE 3.5. And then it lists A through I. So are individuals in these rural areas is there another credential that could be added to this list that they would meet, or something that could be lowered that they would meet? Or is it a situation where they don't have any of these credentials and it's unlikely that they would have a credential before the permanent rules are in place?
Audrey, did you wanna? Yeah, go ahead. So we're discussing the temporary license, right, for the next 4 months. I don't think any of those options are possible within that timeline. I think for the permanent license, that would be something to decide ongoing, but I don't see any of those options listed there. There's, EIPA score requires so many, months of taking a test and getting the results, and that takes a very, very long time. So there would be no way to meet any of those credentialing options for those who don't currently have them. So yeah, I think there are people who don't have any of those. This is Jack. Can I make a comment? Okay. I have a question. So require the EAP requirements and all that, but instead of requiring those, could there be a requirement to show that they're currently a part of an ITP program, enrolled in an ITP program? Would that be something we could add as another option? Credentials listed. This is trying to remember. Okay, so to answer your question, so ORID research regarding licensure and standards. We researched at that time locally, and there was a strong opinion from the deaf community that ITP programs are not really good enough, that's not a standard for quality, that there's some difference of opinion, but that was the strong feedback. And so that was the reason that ORID didn't recommend that as a possible credential, so to speak, is just being in an ITP program or completing an ITP program. So there's concerns, I think, if we put that down, that becomes a loophole forever. So I understand now that there's a temporary situation and licensure is new and all of that, people are supporting it right now, but I would be very concerned if we put that down documented, that would be a problem. Yeah, go right ahead, Eric, we're going to switch control person.
So I have an idea that may address some of the concerns or that concern. I'm a little bit against lowering the bar. I'm not attempting to lower the bar by any means. But we have a license for supervisors, correct? So we have a supervisory license. Is it possible for those who have a supervisory license to, I don't know what we call it. We call it a provisional license or something, so that they can endorse the people that they will be supervising. Because I didn't go, like, if that person isn't going through an ITP, they can still work with the supervisory licensed interpreter. I think that would work for the rural areas, for them to be matched with and endorsed by an interpreter who has a supervisory license. Which would mean that I am helping them learn, helping them grow, and mentoring them. And helping them attain their license. Oh, you know what? I forgot to say my name. This is Eric. Oh. So anyways, as Mish was saying, yes, that loophole, I understand, and I agree. I do not want to create any opportunities for people to avoid this responsibility. But I think if interpreters who hold a supervisory license could commit, let's say up to years or something to supervise and mentor and support those pre-certified interpreters who are trying to get into the field. And so I think we should avoid using the language of interpreter training program or ITP, but perhaps say pre-certified, which would be more broad. And it's not specific to students only because, like I said, in our area, the upcoming emerging professionals are not technically students. And so I say that we avoid the use of student or any education related language. And this is Jack. Go ahead, Heather.
Thank you. So this is Heather. Are individuals in the school setting who are interns that are pre-certified individuals, are they monitored and supervised by someone who holds the supervision license? So that what I'm hearing from Eric would also cover the schools as well, or are they two so separate different things that they are really two categories that can't be merged?
Colleen, this is Jack. Colleen has a question. Do you want to comment, Tammy? Mitch? You both have the educational background. Tammy, go ahead. This is Tammy. Thank you. Thanks, Eric.
I'm gonna go home and fix Tammy before I start.
I'm gonna go home and say, hi, this is Tammy, before I start talking with my family members. Tammy. So I work in education. So what Audrey was talking about, interpreters in the program, students in the program who are currently working towards becoming professional interpreters. Sometimes we place in K-12 settings for their internship. And oftentimes K-12 interpreters only have the EIPA credential, and so they can't be supervisors. They are technically experts in the field of educational interpreting, but they don't have the paper to back it up from RIT to show that they have the credential necessary for supervisory licensure. So we do have a few interpreters who could supervise all of the ITP students who are placed in their internship K-12 settings. That's an option. Is that what you were talking about, Colleen? And this is Jack. Colleen, go ahead. This is Colleen here. I don't have a response, but I am not the expert in education, you both are, Mitch and Tammy. And so I'd like to know your opinion, but I have a question about, the loophole that you were talking about. I'm trying to understand, is there another way? I understand that we can't renew this temporary license once it expires. And those who are waiting to get their test results back. Maybe they can have some kind of paperwork that shows it's pending and have a grace period for those students. Like if they take the SLI of the EIPA, we could ask them to document that with the start of the date they took the test, so to show that they're making the effort at developing their skills and getting these credentials eventually. I don't know who's going to go first. And Jack says, let's just start from the left, Tammy, and we'll go then to Mish and then to Audrey. This is Tammy here. For working interpreters who are currently in K-12, they can't wait because they're waiting. They can't wait for the test results because it follows the ORS. They have to follow the OARs. Oregon administrative rules relating to educational interpreting. So unfortunately, there's no waiting. You have to have your EIPA and provide that as proof. So that won't work in educational settings. That's my 2 cents. Mish? This is Mish. So 2 things. So I'm going to ask that we don't use pre-certified. We don't use that word because it means nothing. You know, either certified or not certified. There's no gray area in between. So those interpreters who are not yet certified. And we'll now bring us back to what Heather asked about the standards and the rules and the amendments or exemptions. So comparing K-12 interpreters in rural areas to ITP students. The students, during their internship, they have direct supervision. They're never there working alone. They have a supervisor with them at all times. And that happens within a 6-month, less than a 6-month period. So that exception could also be applied in rural areas who are technically, you know, for less than 6 months, they're considered students, and they have somebody working with them on site at all times for a temporary amount of time that is less than 6 months. I would be willing to consider that stipulation and exemption. But just to broadly state, any new interpreter, you know, as long as they have a supervisor. So what does the supervisor mean? I think it's too broad for me. If we add the exemption and make it more limited in its scope, I would accept that. And this is Jack. Audrey. Scope and time frame. So to add to what Mitch said, I agree. Oh, this is Audrey. You said my name. So I'm gonna be like, I don't know. Anyways, this is Audrey again. Yes, I'm really happy you brought that up, Mitch. You know, on public record, I want everyone to know that we don't want, after the temporary licensure is over, we don't want this gray area to continue. But as for now, yes, it's less than 6 months. I do think it's going to be impossible. It's impossible for many interpreters to, because they are waiting for their test results. I think there is going to be an impact to access to deaf community members. But again, like Eric said, I don't want to lower the bar either. And so while Colleen was speaking, it made me think of something. What if we set up a schedule for the different criteria for the provisional license? What if we have a schedule with the EIPA saying that they must take the written by a specific date and then provide us with proof? In order to oppose accountability and show that in good faith that they are making an effort to meet the standard as it sits now. And then as far as college students, our program at Western Oregon University is different than Portland Community College. But I think, you know, we really do need to change the curriculum if we are going to abide by this temporary licensure and all of its requirements. You know, we need to have them pass the written by a specific date. And then we have a practicum or field experience requirement that does have supervision. So the licensure doesn't currently align with our current curriculum and our timeline. So I think our timeline needs to be adjusted at our institution in order for them to be able to comply with licensure. And this is Jack. This is Jack here. Question for the three of you. Can you help us understand in general, ITPs, interpreter education programs? Can you tell us how long it is, what the timeline looks like, when students start to work out in the field and get that field experience, whether in their practical or internship placements? I think that'll help give us a better idea of how we can create those discussions if we understand more of the timeline. That's my question. Mitch, go ahead. This is Mitch here. I'm trying to keep it brief. Our program is a 2-year program, and our goal is to graduate students and have them be job ready. So during the 2 years, the internship happens in the second year, about midway through the second year. And again, we always have a certified interpreter who's there supervising the intern. When they graduate, well, let me back up. Before they graduate, the students must take the CASB knowledge exam. So we have that required to complete a program. They need to take it. We do not stipulate whether they need to pass it or not. So they need to take it, period. And with a new licensure, that might change. We might require students to, in fact, pass the NIC knowledge exam, NFC knowledge exam. And again, we're in the effort to graduate job-ready students. This is Jack again. Thank you, Mish. I have a follow-up question. Me not being as familiar with what I remember, you take the knowledge. Do you have to have your bachelor's to take the knowledge exam? And it's just saying, for the performance, yes, you do, but not the knowledge exam. You have to have a bachelor's or equivalent. So 4-year degree. Jack says, thank you for answering my question. Eric? Is Eric here? So again, for us in the rural areas, we do not have any interpreter training programs. So we have more of a grow your own model. And what is that going to look like for us? If we say, if we try and follow school's curriculum, that's good, all good and well when you here, but we don't have that. And so how can we support our emerging professionals in our area? How can we develop our interpreters in rural areas? This is Jack. Actually, would you mind staying there? And then Heather. Oh, actually, we need to interpret over here. Heather, go ahead.
Thank you. I have a question for the rural areas. Are there enough supervisory licensees in rural areas to provide supervision to those who are not yet licensed, who are need to be supervised?
This is Jack. Eric, go ahead. So I can only speak to my area in Southern Oregon. And I think maybe we have about 5 to 7 people who are not certified. We have about 5 to 7 people who have the supervisory license. So depending on, the bill is not very clear about the role of the supervisory licensee. It doesn't say how many people they can hold under their license. Can they have all? If that's the case, 1-to-1, we have plenty. But that's in Southern Oregon. I'm not sure about the other more rural areas, Eastern, Northern, Northeastern. So those areas, they might not have enough to cover their demand. And maybe Tammy can talk more about that, but that's the current state of events in Southern Oregon. This is Jack. Heather, did I answer your question?
Yes, thank you.
Okay. And then Mitch. Go ahead, and then back to Tammy, or back to Heather. I'm having to keep my eyes on who all is raising their hand here, Jack is saying. Okay, so Audrey and then Heather. And then Sammy, pardon me, interpreter Sammy.
Oh. That was, for supervision, we have a couple things. I think what I'm hearing you say is in Southern Oregon and rural communities, you guys do more like on the job training, OJT stuff. And that's really common with you guys are obviously in a new profession, but new to licensing. We did it for sleep technicians, it's common. Second thing is because the law is very broad on supervision, you guys can decide what that looks like. It's over the computer. It's every week you sit down and meet with the person, and that's the supervision. It doesn't need to be, right there on top of them. You can make all those, and I'll bring the rack, all different options on what that looks like, and they can decide, and they'll bring it to you. Maybe they don't know, and I'll bring them all to you guys. So.
This is Jack. Okay, thank you, Sandy. Who was next? I feel like Mish, did you have a follow-up? Or Audrey? You're pointing to Audrey. Okay, Audrey, go ahead, take the floor. This is Audrey. So I want to thank you for that flexibility and what the license would require. I think being weekly as a supervisor, we already have that in our curriculum as well, and so that would match. But will the instructor themselves have a supervisory license? I'm not sure. So I have a question related to rural areas who don't have access to interpreter training programs. Just to let you know, West Oregon University has a fully online system now. We did so to meet the need. So we can support interpreters who are in those more rural areas, so they don't have to physically relocate them on them. And we can get them connected to those online programs if you're interested. So I just wanted to throw that out there and let the community know. Mitch, this is Jack Mitch. So we're going to have an interpreter switch. Interpreter switch.
This is Mitch. In response to what Eric had shared, you talked about grow your own. Do you mind briefly telling us a timeline of what that would look like? So that if an individual in that area is like a locally homegrown signer and wants to enter into the field, is their skill level typically, and how long does it take them to achieve that 3.5 score? Hello, this is Eric. So, the typical interpreter response is, it depends. So we do have some people who move and they have maybe already gone through an ITP and they do not have an EIPA score at the moment. We have local, let's say for each interpreting team, we have throughout the various counties, there may be a small group that has a more advanced skill set. They could be considered a supervisory licensed interpreter, and they would have trainees, they would mentor individuals, they would provide workshops. So for the timeline, sometimes it could be up to a year. If someone has never been through an interpreting program, but they are a child of a deaf adult, they're a CODA, then they would have the same access to mentorship, access to workshops, online programs, And at that time, it may take them a little bit longer to get to that point. I would say an average amount of time without any formalized training would probably be between that 3 to 5 years. Jackie's saying that, Colleen, go ahead if you wanted to make a comment, and then it will be Tammy after that. Go ahead, Colleen. And this is Colleen. I just didn't know if Sammy or Heather wanted to make any comments or responses to what Eric had shared before I proceed. Both of them are shaking their head. All right, this is Colleen. So I feel like I have to answer to every person who shares something because I have a thought for each one again. First of all, educational settings are not my specialty, but I know that OAR already has it specified in the law that you have to hold an EIPA score certification, but for an individual coming into that process, could they have a letter of attestation to show that they took it or are planning to take the EIPA before they start that training or internship? So it shows that they are investing with the EIPA and a knowledge exam, or do they have to pass it before an internship? Would that affect the timeline? Does that create a loophole? Because I'm thinking maybe that would be an easy solution. Again, I'm not an educational interpreter, so I'm wondering if the EIPA, if they had an exam they would have to take for the EIPA. Well, typically, how long does it take for the EIPA? Every 6 months? So at least if they show they put in the effort and that's documented, that they in fact took it, not saying they have to pass it, but they took it and they had a letter of attestation before they began their internship, would that be satisfactory for the provisional so they could continue that? I see there's a lot of eyes. I'm just trying to figure out this temporary part. I can say Mish. I know Colleen was looking at us, but that is something that we do have to decide. I think it's our duty to determine a standard based on community feedback, feedback from the RAC, but ultimately we need to decide for both metropolitan and rural interpreters what those standards will look like. So you were looking at us, but now we're looking back at you. Jack's saying, Tammy, you're up next. Tammy here. Okay, so the OAR in regards to educational interpreting for K through 12 was passed back in 2013. Michigan saying 2018. Oh, 2008. 2008. Oh, okay. They weren't required to comply until 2013, but it was passed in 2008. Yeah, 15 years ago. And ever since then, students from various interpreting programs have done their internships with our interpreters and done just fine. They did not need anything extra. So I think for internships, it's still fine. They're still following and in compliance with OAR. I think that's fine because they're not being hired as the interpreter. So that might be a question for Heather. I'm not sure, but that's how it's been so far. And the second thing I want to share, which may be a little bit off topic, this discussion is great so far. We're discussing everything that needs to be discussed. But also remember that we're talking about the temporary rules. So deciding exactly what it will look like from here on out, it's just till June for the RAC to be able to have the information that they need to discuss, collect public comment, and then share that information with us at a later date. So yes, this is a serious discussion, but at the same time, we can take a breath and we can remember that we need to figure out what we're going to do for the next 6 months and focus on that. And let's just give all of our time to discussing that, and then we can research, we can survey our colleagues, we can do more investigation before we make permanent decisions, permanent ruling later on. That's it, I think I'm done. Jackson, Sammy, did you want to make a comment?
First comment is, it's my understanding that the Department of Education is going to copy and paste what you guys decide. So there's that. Second, is there a need now? Are there people, is there barriers right now with the temporary rules that aren't allowing people in rural areas to get their training and keep moving through the whatever process that they're currently in? Is there something now happening that we could fix temporarily? And then we would move it into the permanent rulemaking process, which needs to happen before June. So this conversation is going to move into the wrap very quickly.
Jack is saying Eric. Eric here.
Yes.
Yes, people in Southern Oregon. If we do not have particular language to amend it in order to allow those who have a score under 3.5 for the EIPA, maybe like mentee or some kind of, I don't know exactly what you would call them or how you would label it, not pre-certified. But yes, we do have people currently that if there was not an amendment to that, they would not be able to work. That will impact students. K through 12 students.
That's a requirement now. In K through 12. The 3.5.
Mitch had said, but is that being followed? Heather, yes, go ahead.
This is Heather. So currently with the temporary rules, there are people in the public who are not getting the services that they need because in certain areas, they can't get their provisional licensure. Is that what I'm hearing? Thank you. And then
Eric responded, yes.
that also applies, this is what I'm hearing, tell me if I'm wrong, that those students, separate from that situation, students who are in current programs cannot continue with their training in their internships currently because they do not yet qualify for the provisional, and so they can't continue with their program.
Go ahead, Mish, you want to make a comment? Oh. Does everyone need a break? Jack is saying, yeah, I am going to decide that we will have a 15-minute break. Be back at 11:35.
Now, Alice, join me, please.
Yes. I am officially resuming the meeting at 11:47 and announcing that Al Mascarenas has arrived to the meeting. All right, we will begin with a comment from Mish. Hello, Mish here. I wanted to make a comment in regards to our discussion. I support new interpreters. I support the growth of new interpreters, absolutely. At the same time, the standard of the 3.5 score is already low, which means that interpreters are only providing maybe 75% of the message that teachers are trying to convey to deaf students. who already experience additional barriers. So if they're only receiving 75% of that information, that is a great petition for me. I think the standard should be 4.0, that should be the minimum. 3.5 is already well below that. So it's a struggle to find a balance between establishing fair standards for the deaf students and growing more interpreters, because we do need more interpreters. So that was my comment. Thank you. Was there an additional comment from Eric? Eric is signing no, I'm good. Jack signing. Okay. Colleen? Colleen here. Listening to everyone share their thoughts around the room, I'm wondering if we could consider combining the 4 into 1 and on section 6 for the provisional, if we could include those 4 criteria, would that satisfy the requirement with, so that it's not a mountain people have to climb to achieve it? If you could have a letter of attestation that you have passed the written exam, and that's a quick turnaround time for the knowledge exam that is passed. Secondly, shown the effort of taking any sort of performance exam, whether or not that's the EIPA, NIC, ASLPI, whichever, just evidence that you have taken a test and you are pending the results. Thirdly, to show some sort of documentation that you are currently a student at an ITP, or that you are currently working one-on-one with a mentor through a program or any type of training. With that, take care of the need in Southern Oregon for newer interpreters coming into the field, that they can have that additional training, such as workshops, for example, just to have documented proof that they are continuing their training. And fourthly, if they could have a letter of support from a deaf peer, a colleague who can attest to their skill. So could that be an instructor, a deaf colleague? And if they have those 4 criteria, would that satisfy the requirements so that they could begin an internship? That's my question. Clarifying question. Jack says, Mish, go ahead. Mish has a clarifying question. So firstly, the knowledge exam. If it is passed, then you can already get the provisional license at that time. So it would really only be the 3 other criteria, which are, well, taking a performance test, showing proof that you've taken a performance test. So that would mean showing the effort that you're working towards a goal, you have a certain timeline, and I would pay for that. Can you expand more on that point? Yes, so maybe they wouldn't be able to take the exam yet, but they would have a letter of attestation that they have a date scheduled, the fee has been paid. It would be a letter of proof, a verification that either they are pursuing training through an ITP, a workshop, or as Eric, I'm not sure what you would call it, your continuing education workshops. It's like their own training, just to show proof that you are continuing your training and have a letter of support from a deaf person, giving them their blessing, so to say. Mish, again, trying to chew and sign at the same time. Jackson, Mish, go ahead. Sorry about that. I just took a bite. Okay, I understand. Okay, so for the last criteria you mentioned, my only concern is that if you approach a deaf consumer in a rural area, there could only be one deaf consumer in that entire area. So that puts them on the spot that they have to sign a letter of support of this interpreter. And also, somebody who is deaf with a general license or supervisory license, who is deaf, would they have to have a license? Would that be acceptable? Colleen here. Let's see, in Oregon, there's what, less than, I can count on my fingers, 3? Well, Jack is saying, for CDIs, there's only 3. Well, I mean, I can count on both hands how many people are, yes, teaching, Mitch is saying teachers, right. I was an ASL teacher or a peer, so I don't want to put the burden on the deaf licensee because there's a limited amount of people in the state. And I can't write a letter of support if I haven't met the person in your area, if they're in a different geographical location than I am. So if it's deaf or supervisory licensed, oh, Sammy has her hand up. Jackie's saying, Sammy, go ahead.
So a couple things. If you guys are saying that there is a need to have some kind of exception or whatever you want to call it for students who are in a program, for people who are in a rural community, or people who are a child of the deaf. You could, in assuming that we're still talking about provisional licenses, which require supervision, you could have everything under 6 be one option, and then you could have, or as a student attest to being in an education program, or attest that you intend and hold a credential under, that you're going to hold the credential under 6. So you've got 3 options, all would require working under supervision, but you have 6, anything under 6, you're in an education program, or you intend on getting whatever's happening in the future, and you could put a time in 3 years, in 5 years, in 6 months. And you could give HO a direction if it's a need now, immediate, emergent need, to amend the rule we are in place.
Jack says I can respond to that. Here's my comment. A question for you, particularly about students and the urban students. It's broad and specific at the same time. You know, students must be under a program. I wonder if we could use any other specific language that could offer that flexibility without lowering the bar, so that there would be flexibility for that individual to receive mentorship, on the job, mentoring, novice. Mr. Sunny, novice. Okay, novice. That sounds good. Yeah. Mr. Signing, I think having that support, that letter of support from a deaf person is important. I'll have to think of how to phrase that. Sammy, go ahead.
So just so I'm understanding, so if Audrey couldn't get a letter of support, she couldn't get it, would we be denying her a license?
She wouldn't qualify.
She won't qualify? Because that would be way outside of licensing standards. Jen. Way outside.
Audrey. I feel like legally, that's a very nuanced phrasing, because who identifies as deaf? Who identifies as culturally deaf, hard of hearing, an interpreter? I think it's very nuanced. And so legally, how you identify who's the right individual to have that letter of support, I feel is out of licensure bounds and our abilities. Jack said, I'll add on to that. This is Jack. I agree with you, Audrey. Yes, it is very complicated and nuanced. So since HLO will be responsible for administrative work and monitoring, then how do you prove that? Do you have an audiology result, a test, audiogram? Do you show that they have a job in the teaching field? Right, as a deaf person, I can agree. How do we define who is deaf? What's the right language for that? Mish, go ahead. This is Mish. My comment is a little off topic. I know we're focusing on the EIPA, but we have not yet considered the ASLPI or the SLPI. So between those two, we could accept whichever level we prefer for the temporary one. I believe now it's currently set at 4.0. Is that the same for general? I'm not sure. For medical, Jack is saying that's my understanding. Which is saying, well, we can also consider the ASLPI or the SLPI. I can't remember the specific number for each of those, but for the provisional, we can decide and determine what's fair, what score level is needed for the ASLPI for students and for rural interpreters, so that they would be able to have a score that is acceptable to us. So we haven't discussed that yet. I wanted to throw that out there. Jack is saying, I found that the SLPI is already listed here in the document under section 6. It is under D, C and D. Sammy said advanced.
D is advanced.
Advanced or above. Jack said, let me offer a clarifying comment. Two separate things, I want to be very clear. One is the ASLPI, which is a 4.0 or above. The SLPI is advanced or above. Just wanted to offer that clarification. Audrey. I just wanted to express publicly that, and have it be documented, my concern about the assessment, and is that enough to qualify for a supervisory license? I feel that we have a lack of information regarding the assessment, and if the interview is only done in one language, such as the ASLPI, is that a sufficient assessment to qualify an interpreter? And maybe this might be a different conversation. Maybe that's more relevant for the permanent rulings. But those are my concerns about those two assessments and whether or not that would be enough to qualify. Colleen? Colleen here. Yes, Audrey, you make a good point. That's what I was trying to figure out, something for the temporary aspects, we can transition into the permanent. For the language proficiency exam, you have a conversation one-on-one with a deaf person. I understand that part, it makes sense. At the same time, honestly, I think that some of their skills are dependent on the job and the setting. And that is something that we need to give a space for those to practice. For example, legalese for newer interpreters, they have to figure out and learn about the legal settings and proceedings. Jack say paralegal, is that the right word? Paralegal, no, it's the student who has completed some training but has not yet passed by a certain point. That's what I'm labeling them as. Audrey's saying like a medical resident, so to say, like a medical student who's in their residency, correct. So they haven't completed everything yet to achieve that final title. So how do you transition from that internship to a title that's more specific? I know we can get into, the law is already passed with that, and we can get into semantics. But if there's documentation that allows them to have that practicum in a way. So it's just something that proves they have the effort and are committed to following through with it. Mish, Jackson said, Mish, yes, go ahead. Mish, just one flick for my name sign.
Just want to make
Jack
sure.
was signing my name sign, incorrectly, so just wanted to clarify.
We were talking about provisional.
Oh, let me first give the floor to Mish and then I will turn it over to you, Sammy. So a follow-up in regards to Audrey's comment, if you remember, we have deaf interpreters who only use sign language, and we have to provide options for them to become licensed. So with that information, yes, I do think that the ASLPI and SLPI standard of the 4.0 and advanced should remain. Because that's not a great fit for somebody who uses English as a primary language, as a hearing interpreter, but that could be an excellent fit for somebody who's deaf or a deaf interpreter. So EIPAs, an additional language assessment in English, there should be an equivalent in ASL, and in order to provide access to licensure. Sammy, go ahead.
I want to just make sure, before you spoke, Audrey, we were talking about provisional, and I think you swapped over to supervisory. You did say, you said supervisor. Okay, so we're still talking about, okay. So make sure I understand. You're saying that the IAS, is not sufficient to get the provisional? What you said is supervisory. Just want to make sure I understand.
One moment, interpreter search.
Okay.
What I meant, I'm not sure what sign we're using for provisional sign that we're provisional. It's confusing though because we have temporary licensure and then there's provisional licenses that will be a permanent. So let's decide on a sign because what if you use that sign? Yeah, the sign, it's confusing when we're trying to figure out the sign choice of provisional, supervisory. So you want to assign this way for provisional? Provisional, okay, kind of looks like practice, the provisional license, okay. I have concerns about the assessment for a provisional license. So I want you to respond to this, saying that there's no other option for deaf interpreters. Cassidy, CASLI has a deaf assessment for interpreters. There's also PEI that has an option for deaf interpreters. So it's not the only point of entry for deaf interpreters to go through the ASLPI. So I wanted to say that. And Jackson is next. Is there another person we? Go ahead, Eric, you go ahead and then I'll go next.
I didn't even think about that.
No, you don't remember my, oh, yes, my name sign is like steel, crook. My last name. Okay. Let's see. So I've been taking a look at the temporary licensure paperwork here. So it doesn't mention a written test in there. for the provisional. Commission says yes, under I, it says knowledge exam.
Doesn't just say the word.
So that's the EIPA written, is that what that means? Castly acknowledge exam, okay. So, but just to clarify, so that means that we will accept Castly, but not EIPA? Okay, we're gonna switch back to this to clarify. They're so sorry, I'm still chewing now again. So Castly's new exam is half ASL and half English. So that's why it's not an assessment, but it's a test. If the person takes the test if they don't understand ASL, they would fail. The EIPA is written, so it's a written English test. So there's no assessment or testing about signing for that. Eric says, can I comment again? And Jess says, yeah, go ahead. Okay, so this is Eric. For educational interpreters, right, EIPA, it's for educational interpreters. So why would the EIPA written exam not be accepted equally to the Castly knowledge exam? I understand, yeah, because people that in my area, obviously many of them are educational interpreters in K-12 settings. And forever, the requirement has been the EIPA as the credential. So as things have gone along, people have taken the written test and the performance test for EIPA, but they really haven't taken a Castly test. So to say now that we are accepting the Castly knowledge exam, not the EIPA written exam, is difficult for people in my area who have already committed to educational interpreting, have taken the EIPA written exam, and now, you know, if we follow the grow your own type of structure that we have been doing, you know, they're going to be they're really training and practicing to become educational interpreters. So I think it's important if the Castly exam is accepted, then I think EIPA written exam should also be accepted, because that is specifically for educational interpreters. Tammy, go ahead. Tammy says, well, Jack, you were supposed to be next. Jack says, well, that's all right. You go ahead and then I'll. Mrs. Tammy, okay. I think we're confusing two different topics. There's a provisional license, that's for freelance interpreters. It's not for educational interpreters, correct? This is a general provisional license for freelance interpreters. And then we need to invent a provisional license then maybe related to educational interpreting, like a driver's permit. So the EIPA written exam is specifically for interpreting in educational settings. And they're asking different words, different English vocabulary, what it means. It's a different skill. It's not related to general interpreting that test at all. So to add the EIPA in for this general provisional license is inappropriate, because the EIPA is specific for educational interpreters. So if we want to create a permit for educational interpreters that could include interns, that could include people who have not achieved the 3.5 in the EIPA yet. This is my opinion, sorry. But people who have not achieved the 3.5 on EIPA should not be interpreting for children, period. They do not include enough information. They are not providing accurate access to those children's education, period. The minimum for educational interpreters should be 4.0 and above. That's my opinion. And so the people who created the EIPA, they did research, they gathered information on their test ongoing in the past, and they have data that shows how much content is included and how much is missing. So someone with less than a 3.5, they are including less than 75% of the content and the information to those STEM students. So on their best day, if they're including everything they can, everything the teacher is trying to impart to the students, that student is getting minimum of a C, a maximum of a C. They can't get that, they can't get above a C because they don't have that access to that information. And our deaf students are coming to school sometimes and they don't even know that they're eating a food that's called pizza. They have to ask another kid, they're asking, what's the bowl? What's that stuff in the bowl when you watch a movie? What's that called? They're signing popcorn like this, like tapping their head because they don't even know what popcorn is. I mean, they have no idea. So the educational interpreter has to see the student and understand, oh, okay, that's the home sign, that's the sign you use. Okay, we're going to use that sign that's yours, that you use at home, that's your specific sign. You use that sign for a while because that's a sign you know, and then slowly replace it with the actual ASL sign, with the correct sign, and reduce that sign that they're using over time to increase their language understanding in ASL. It's a huge responsibility that interpreters are working with in educational settings. So for an interpreter to have less than 3.5 on the APA and interpret in educational settings is unacceptable. It's inappropriate. So I do understand at the same time, we need to grow more interpreters. We need a larger number of interpreters. So how do we do that? Right now, we're talking about the temporary licensure. So can we create a temporary permit that allows someone, like when my kids are driving and I have to document how many hours we've driven on the road together for their driver's permit. Maybe there's something where you document how many hours that interpreter has spent with the mentor. I don't know. I don't know if we can set something like that right now for the temporary license, or if that responsibility would go to the RAC for more for the permanent roles. I'm not sure. But I think we need one more, sorry, Colleen. I think we need one more layer of license. I think we need one more license, really. Some kind of a provisional permit to include those interns, include those people who don't have the 3.5 EIPA score yet. And Jackson, thank you. Thank you. Okay, Mish. Okay, this is Mish. To clarify, yes, so provisional licenses and educational licenses are different. And students are kind of in both places. As far as ITP students, they're in, they're freelancing within an educational setting and K-12 setting. So there either needs to be some kind of an exemption for those ITP students, or to have something in both where they have the ability to be a student and also be an intern in those sites. So I'll ask, the people who know, the people over there who know what they're doing at the end of the table. I'm not sure which individual, but is it possible to add like a conditional provisional license? So not a new license, but like a sub point under the provisional license. Jack says, I like that language. Let me make a comment. What did you say, Tammy? Oh, that had an okay. This is this is that, yeah, conditional license, yeah, conditional permit, maybe we don't want to use the word license. But related to what Colleen was saying, for those who are practicing, who are learning, and, you know, like you said, with, instead of having maybe a deaf community member sign off on them, so to speak, but maybe to get an ASLPI or an SLPI evaluation and have that instead, and we could decide what score would be required for that, but that maybe would be another way to get, you know, approval from a deaf person or from the deaf community without burdening one specific member who is in that person's area, physically in Oregon or, and then what was the, I forget what you were suggesting, Colleen, to say that I have a date, I'm going to be taking the exam on this date, and then I'm either a student officially or I'm doing continuing education, and then thirdly, the ASLPI or SLPI as an evaluation. Did you call on me officially? Oh, says yes, Jack says, go ahead, Colleen. My main thought for any kind of assessment and putting that in is how long is the turnaround time? I know we all know that whatever specific field that we're in interpreting, it's usually a 3 months to 6 months to do an exam. Like I asked earlier about EAPA, you can get performance results maybe in 6 months. So the turnaround time is my main concern. So if there's something that's required for a license, and it's going to be taking longer than a long time to get the results, then I think that would be good to say, oh, I have taken the test, this is the day that I took the test, and I'm waiting on results. I don't want anything to be dependent on getting those results back in a timely fashion. So you, Jack, you just asked me about, and you mean it for permanent? I think for permanent and for this temporary period over the next 6 months, I think it's going to impact both. It's just something that we need to consider. If we're waiting for the results of an exam, that can get really arduous. It gets behind and people don't have the ability to start work. So I think showing that I've made an attempt, I've taken the exam, or I'm taking it on this date, I think that would be sufficient, because it's really out of our control as far as when the results of different tests come back, because that's dependent on the organization that provides the test. So to have something that says, I mean, if we just have a letter of attestation, that could be, you know, a month process, maybe turnaround process time, and rather than 6 months or however much time to take for a result. Just as I'm curious about for the provisional, when you would get results for that. Sorry, Sammy, we've been jumping back and forth, but you want to go ahead and make your comment.
Make sure that I'm clear. So let's start.
Hang on 1 second, we're getting in the picture. Okay.
I can unpack this a little bit. And provisional interpreter cannot provide service in the educational setting. It's in the law. It's just, you can't do it. So there's that. Start that. I want to make sure that I understand. I think what I heard Tammy saying was, for educational interpreters, it should be a 4.0 or above on the EIPA by itself. So that's that category. I think what's tripping us up is that because our temporary rule has a laundry list, including the provisional including having the education piece as an option. But probably when you guys do your rules, that will be there. So if you pretend like it wasn't there, that I think that might get you there here, because the provisional is that it's your learning license. Yes, and your education isn't your learning license. It's you're in a specialized place doing interpreting for specialized group of people. Does that help? Maybe not.
No, I think you covered it.
Okay.
I think Sammy covered it in terms of making that distinction between professional and educational.
Okay, thank you. Audrey, yeah. Says Audrey, I wanted to respond to Colleen's question about the SLI knowledge exam and then the EIPA written test. Maybe we should double check. My understanding is that you get immediate results when you do it, because you do it online, so it's just immediate. And this says, I think it's 3 weeks. Trying to say, no, it's right away. So the letter, the actual letter will come. Yeah, and obviously, I'm clarifying, not the performance, but just I know it's all on the computer, and then as soon as you finish that computer exam, the result pops up, and it's submitted automatically. But I believe, we need to research this, but this scheduling the knowledge exam, it takes a lot of time between when you can schedule and when you can actually take it, yeah, for the knowledge exam. You have to schedule and go to a physical testing center. So I have no idea where the nearest one is in Oregon, what the options would even be, and how long you can wait. You might have to wait to schedule that knowledge exam. You might have to wait 2 months just to even be able to take it or get a scheduled appointment. So that's something that we need to talk about with OSC as well. Jackson, thank you. Is there anyone who wants to add? We're going to switch numbers.
We need to know what
So we were
you're
just
saying.
talking about provisional license, is that correct? Mrs. Jack, Sammy?
Is there anything that we could fix now that will help people get licenses now? Or help them do like a carve out, an exception for a period of time? For example, if you're on the registry for health, you don't need to have a medical license right now. Any license, you wouldn't have to have any license if you're on the healthcare interpreter registry. What can we help you with now? Maybe there's no.
Jack? Mish? So basically, it's time to make a decision. So I wanted to ask something. We're talking about the provisional license itself. For new signers, new interpreters, people who are learning. I think our concern is that the provisional license says that it could go up to 6 years, and I feel like that's a very long time. If our current standards get lowered and someone's not qualified, they could continue to work for the next 6 years without being properly qualified. And so I think we need to have some kind of conditional provisional license. This is my question. Is it possible to do that? Possible within the rules to add that conditional provisional license that we can, remove after 2 years or something to allow a little bit of grace during this transition period. Jack, Heather?
So this is Heather. So a provisional is working under supervision. So for those 6 years, they would be working under supervision, right? They're not just out there interpreting. So does that address your concerns?
You get to decide.
So for the temporary, while the temporary licenses are in place for 6 months, it says that supervision can be on-site or remote, I believe. And then in June, when you do permanent licenses, you would be able to further define what supervision is. So that's something you would be able to do for the permanent provisional licenses. That would be for the 6 years. But for the temporary, for the next 6 months, they have to be supervised. And the supervision says remote or online. And so perhaps that concern about what is supervision would be further defined in the permanent rule. If that would address that concern.
6 months is not enough time. It's 6 years is too much time.
6 years is too much time for being supervised.
Jack, Audrey,
It's a good limit.
so I think this comes back to my question. If we add some kind of conditional provisional license, is it possible that we only have that amended for the temporary the next 6 months, and then we can bring it up to the RAC and discuss on further rulemaking? Or would that not be included in that?
Please say it again.
Sorry, that was very confusing. I'll say it again. So we were talking about adding some kind of waiver or conditional permit. Focusing on the current barriers, but from today to the next 6 months. And then the RAC, they will be setting up the permanent rules for licensure. So I think if the problem is if we set up a permit now, or if we introduce that idea. And then we can have, then we would add a different, or suggest a different structure for the RAC for the permanent rulemaking. Could that get confusing? You know what I mean?
I'm not sure what you're trying to fix in this 6 month. We switched topics. We were doing rule, and then we were doing students, and now we're doing students for 6 years or 6 months. Is that right?
This is Jack. Audrey? Yes, I think that's the problem. So what we are we're trying to propose a short-term solution for those interpreters who maybe don't fit into these boxes yet, for them to continue. So I was just bringing up my concern about that exemption or permit, creating layers of confusion when the 6 month deadline comes. And it then goes back to these permanent rules that will have a bigger impact. I think will cause confusion. And I think this confuses conversation. Jack calls Mish. Mish. What I need to fix at this moment, on Monday, PCC students will start their internship next Monday. They will start interpreting, but it's illegal on Monday. And so that's the part that I need to fix for my program. We need to create something that allows students to go to their internship sites and practice their skills in this practice profession with real clients without being penalized.
So
And Jack calls Sammy.
I would suggest is under the provisional, which we have now, is 6 gives you the list of all the different things. They don't fit into that. They don't fit into 6, but they do fit into being under an education program.
Oh. Yes, educational license.
So if you have 6 and then, or in an education program, and then if you wanted to fit the rule control in there, or under supervision of human. And that should get.
This is Jack.
Or
Heather.
we tend to hold the credential.
So I think what the confusion is, okay, we're listening that there is a student concern and intern in their program. So what Sammy is proposing is that in addition to credentials under 6, that they would be able to get that provisional. If they're in a student in a program, it would fix that problem for the intern comes in on Monday. they could get their provisional because they're a student in a program, and they could fix that by getting a provisional license, then they would be able to do their internship and not hit that big barrier of not being able to fulfill their education. And then the separate concern would be, I think that what Sammy is proposing is that if there's the additional concern of people who are out there, whether it's in a rural area or it would be in anywhere across Oregon, who also does not fit 6, also is not a student in an educational program such as an intern, but if they attest to their intent to get one of those certificates that's listed in 6 within the next 2 years or when, then that attestation would allow them to get the provisional license so that then they would also be licensed. And then where we were wrapping our heads around is that conversation of the provisional license is separate from the educational license, because a person with a provisional license cannot operate in an educational setting. So that educational standard is separate, but that's what the fix would be if we're hearing what the concern is for trying to fix things for 6 months for the urgent need, making sure consumers are getting access to services, making sure students can still obtain their education.
And then you wouldn't need an extra license.
Right. But that, hopefully we're hearing and understanding correctly.
This is Jack Mish. So one clarification and one question. For Eric. Can I just leave my train of thought? So our PCC interns work in both places, out in the community as freelancing interns and in educational settings in K-12. And so with that solution suggested apply to both internship placements, because we need that.
We say it again.
We would need it to apply to both.
We say
That would satisfy our needs. And Sammy just asked if I can repeat that. Yeah, so PCC, our students and interns will be assigned to both places. They will be working out in the community and in education K-12 settings. And so
I see.
would,
Oh, you want provisionals to work in education settings.
Yes.
Get it, but you can't. But if you create a conditional license, you could.
So,
Say that
circumstance, we could create
Yeah.
that in an extenuating circumstance.
yeah, that's why this seems like we're bouncing around from subject to subject, Mr. Saying, but they're actually related.
Yeah, okay. So let me make sure I understand. Somebody in the education program who's interning is interning in the community and also in K-12.
Yes.
You said that, I just didn't hear it earlier. So what you could do
That's correct.
is
Yes.
do an extenuating circumstance that might look like the board feels a need, that's an extenuating circumstance that I don't know.
So an extenuating circumstance takes them out from all of the licenses. For an extenuating circumstance, it says you don't need to be licensed at all if you fit this criteria. So if it was an intern student in an educational program, some sort of educational program or some sort of whatever it is that you're boxing them into, then they would not need a license. So that would be a way to allow those students to be able to work in both the educational setting, because they wouldn't need a license, or in any other setting, and to still continue to get their training.
This is Jack Fish. Thank you for clarifying, because now that you just said that, I think, wow, okay, that's a broad exception. It could prove a little dangerous. I think maybe the best way is to add something to the provisional and add something to the educational licenses, if the board agrees. So now to my question to Eric. So the word intern, Does that fit, would that fit your needs? Would you consider them interns? Southern Oregon? Eric signed, I think we could. So if the board agrees to add to the provisional license and educational licenses, something that accounts for this population, maybe we could say something like, so these different credentials or interns working under direct on-site supervision. Will take one or more of these credential exams within the next 2 years. What do we think? Jack? Tammy? Sorry, Eric. This is Tammy. Sorry, Eric. Interns working alone in educational settings must follow the OARs. They have to have a 3.5 IPA or above, period, if they're working alone. If they are not working with certified interpreter, if the certified interpreter is not even with them. And Mish was saying that we would require them to have somebody on site with them. Yeah, but thinking about, provisional interpreters in general, working with a mentor, I think we have to be very diligent and clear with our language to make sure that we are in compliance with OARs. This is Jack speaking, Colleen, and then Heather. Or Heather, go ahead.
Thank you. Tammy, I think I want to make a clarification, make sure I understand what you're saying. So when we're talking about the licenses that we have jurisdiction over, that that just means they either do or have to have a particular license. But then OED has its standards currently right now as to what is needed for their school setting. And so I think what I'm hearing that you say is that they still need to meet those standards until OED, who has authority over their rules, changes their standards. So what we would do or not do is either say you need a license or you don't need a license if an exception comes about, something like that. But that doesn't affect what is required by OED at this current time until they change their standards.
We do not want them to lower their standards.
And so I think I'm picking up a little bit more, but I want to make sure I understood what you were saying and that that's correct. Because we don't have, right now, we're not changing anything about OED. That's what they have to do.
This is Jack. Sammy?
And no matter how you swing it, if you're given a provisional license, they can't work in K-12, legal, or medical. It's very specific. So unless you had a different type of license and or lower the standard, well, you end up lowering the standard of your generalist or supervisor license, I suppose, to give them that. You can't tag provisional and then let them. And that's because the legislature says it.
Says, Audrey, go ahead.
So I just want to clarify what it means to work in that setting. If they are not paid, an unpaid intern, then it's unofficially employed for the school or the district. I'm not sure if that discussion is happening with your internship process, but it was with Lou when we were doing placements in educational settings. That intern in a way avoids the OAR because they have not been officially hired yet as an interpreter. As they develop the skills to become a professional interpreter, then they enter into that. So is it different now, Mish? You're saying that it's different now? There's title protections now. Okay. Oh, never mind. Jack, here, I'll make a comment. A question for you in regards to the exemption for interpreters who are still learning in both K through 12 and community. So community is a very broad term that could be a medical setting. Do you mind explaining how you define that, how you place students in community settings and what kind of jobs they're placed in? That's my question. Do you mind sharing about that? Mish? I said community, yes, which is broad, but students never work in medical settings and they never work in mental health settings. We're talking about football practice and soccer. Jack is giving a thumbs up. Got it. Yeah. Low impact settings as well as K through 12, which is a high impact setting. But so it is. Jack is saying thank you. Jack speaking. Anyone want to continue the discussion, make additional comments? Colleen? So I'm not sure that you understand that ITPs and novice interpreters would not be alone. They would not be working alone. They would always be with another individual. Sam is saying, is that directed at me? I know it's directed at everybody. There's a lot of assumptions about how things are run. So I just want to clarify and emphasize that they would not be alone. They would always be paired with a more seasoned, whether or not they are certified interpreter alongside them. And the question is, with what kind of license can they be mentored as compared to being alone? So that's the question. And that's it. Oh, Sammy. Thank you, Colleen. Sammy, go ahead.
You could do a specialty license, like an intern specialty license. I mean, it doesn't really, there's no parameters about how to do a specialty.
Which is nice. I was like, could you repeat that, please?
You could do, the bill allows the board to create specialty licenses for unit. So you could do a specialty intern license or something like that. Process it.
Right,
I know, it's a lot to take in. Makes your head spin. All right.
Yeah.
Like me, huh?
Okay, I don't know if we're ready for a formal motion yet, but I would like to request the board to make a specialty internship license or intern license, specialty license for interns who can work with direct on-site supervision. Jackson, oh, was that? There was a missed comment. They're just saying, with the understanding that they cannot work in medical or legal settings. Jack say, so that would be required later. Tina, do we require a second? Ms. just saying, no, it's not a formal motion.
We have already
Not a formal motion. Go ahead, Tina. We just want to clarify. Yes, Tina, go ahead.
And how long would that license be good for?
So many questions.
Right.
Heather, yes, go ahead.
So if we're establishing it now, to fill this urgent need, it's a temporary rule. So it only lasts as long as the temporary rule can stand, which is 180 days. And then you would want to consider that for your permanent rules later on. So that's how long it would be.
Audrey's giving a thumbs up. Yes, with both hands. Jack, I would like to comment. A sigh of relief from the entire room.
We just need to flush out like an application. What is there other requirements? We're gonna look at get your ID, those types of things.
Eric is signing, well, we could have a letter from school, but we don't have a school. It's just saying, right, sorry, I forgot that.
Supervisor,
A letter from a supervisor,
or just.
calling his name ESD, something like that. A professor, supervisor, I should say. Yeah. Okay, Jack, you're going to make a comment, and then we'll pass on to the next. So, great, I think we can all agree on having a specialty license. And as a deaf community member, not all deaf community members are familiar with the terminology. So perhaps we could have a different word that the community members who are deaf could understand. You know, it might be thought that, oh, you have a license, that means you're good across the board. So, you know, there's like a specialty license, but maybe we could call this license as like a permit instead, like a driving permit, same kind of idea, that they're learning, you know, you can get on the road and you can practice. You can practice interpreting, the same kind of idea. So as a deaf community member, I just am considering how that would be perceived by other deaf community members. So if you just have the word license, that could be easily misconstrued. I think that if we used a different term instead, that would be clearer, so we don't have to rely on the perhaps confusing aspect of the English language. That's what I wanted to share. Sammy was nodding her, Heather was nodding her head.
Thank you.
Oh,
This is.
sorry.
this is
Sammy was
Heather.
nodding her head. Jack saying, Heather, go ahead.
Thank you. We can call it a learning permit. We could call it whatever you want to, and then it would be defined later as a
Something like that.
license.
Yes.
Because of the law, because that's what it is. But we can call it by a different name for that need. Thank you for letting us know that.
Great, perfect, like that.
So in fleshing out these requirements, a letter from a supervisor, does the supervisor need to hold a license, or is the supervisor just someone who's saying that they are supervising?
Mish? Yes, somebody with a supervisory license
Or generalist?
or a generalist. Or a generalist till what, 2030,
Yeah.
or whichever year is in the law. Yeah. Jackson, great. Pause, finally.
Is there any like? Macaroni salad, is there any other types of requirements you want them to meet? Anything? Have a supervisor give us ID and help you.
Fish is saying, I think we should just keep this up.
Okay.
6 months. 6 months. Keep it to the temper. Jackson, yes, Colleen, funny, I second that.
And then we'll bring it to the rack and let them do more work.
Great, Jack is signing.
Thank you. I'm a recap person. I like to recap. What I'm hearing is that this learning permit is for a person who can work with direct on-site supervision and for the purposes of learning. But they cannot work in a medical or legal setting. They can work in the educational. They only need a letter from their supervisor, who has to hold a license, a supervisory or generalist in accordance with the timelines in the law. They need to give ID. They need to fill out the application. And that's it.
What do you mean? Put on the application.
Oh, okay. So they wouldn't get a letter from the supervisor. They would just attest to saying that they have a supervisor.
Yeah,
They would
there's a bit on the form of supervisor.
provide information about their supervisor.
No need for extra.
It's just, I'm good enough.
Okay.
6 months and that's it, so.
So then we would be ready for a motion and say.
Actually, I don't know how to say it.
Oh. Have what you say.
Mish. We're all looking at each other trying to figure out who's gonna do it. I don't remember the wording. So I'll try. You can feed it to me. Okay. I move that the board establishes a specialty license called a learning permit that allows an individual to work with direct on-site supervision by a supervisor, cannot work in legal settings or medical settings. They must apply, provide a form of identification, a letter of attestation. Oh, just a letter.
Just sign it.
Attest
Attest,
to having a supervisor.
interpreter clarification, attest to working under a supervisor. Direct on-site with the supervisor.
And provide the information that was previously
Need
listed.
some additional information.
That's all.
Say that again. Can you repeat that, Heather?
Provide the additional information HLO requests, like the identity, filling out the application, the name of the supervisor.
Yes. I second that. Tammy, I second that. You both seconded at the same time. Okay, I just want to make sure that I'm doing the proceedings correctly. So do I need to restate the motion and take a vote, or do we take a vote from here?
From here, you would just do the roll call, since there's been a second, a first and a second, then you just
Okay.
do a roll call.
Okay. Do I have to follow like an order for roll call, or I can just go around the
Either.
room? Okay. Eric Crook. Aye. Tammy Adams.
Aye.
Mish Katek. Aye. Audrey Loudenbeck, Ramirez Loudenbeck. Aye. Colleen Bayer. Aye. Alamos Cadenas. Aye. John Ludwig. Aye. Applause around the room. Okay, now, do I have to restate that? I don't remember the English phrasing exactly, but the motion was brought up by Mish to move for the board to establish a specialty license for a learning permit for those who are still learning, and they must have direct on-site supervision with the supervisor, and then have a signed form, a form of ID, as requested in order to pass or have that specialty license. And the motion carries. Great.
You guys know the right rules now. You know the rulemaking process.
The hard way.
Oh, no, it was collaborative.
Okay, Colleen has a question. I'm wondering, and please educate me, with the board meetings, we're making motions, do we have a chance to check with the public? With the public for commentary about the recent motion that was just made?
Under public comment.
Or do I just pretend they're not there and I don't listen to public?
Under 7. The hot time to. Well, you guys went over, just move right on.
So. We're still on yesterday's.
Okay, so, and then I make a motion to close this part of the agenda, do I have to do that, or do I just proceed?
We just proceed.
I would just have us proceed with today's agenda.
Okay, just wanted to make sure, I'm still learning parliamentary procedure, so make sure that I am doing everything how I should. All right, so I'm gonna move on to the next part of the agenda. Yeah? Okay. So I assume that now we're gonna be entering into the executive session, or are we gonna be continuing the rulemaking decision process section?
Executive session.
Okay, well then I've got a script here that I need to follow. I'm gonna go ahead and start. Eric is requesting a brief recess. Yes, 5-minute break. Be back at 1:05. And after the break, we will commence the executive session. Okay, be back at 1:05.
Heather and reminder that we are correct.
Hello. So we only have cart caption usually. So we probably need to put on the agenda how to do it. So do the executive session.
And we'll go ahead into executive session at this time. We're gonna jump to the agenda after that and because of time constraints. So I think we're gonna move on to the more important items under board action after the executive session, and then we'll have public comment at that time. So we're gonna move into executive session at this time. The Board of Sign Language Interpreters will now meet in executive session pursuant to ORS 192.660 2F, ORS 192.3559A, and ORS 40.225 for the purpose of considering information exempt from public disclosure at 1:11 p.m. on January 4th, 2024. Representatives of the news media shall be allowed to attend the executive session. The public will now be moved into a separate breakout room for the duration of the executive session. Please continue to keep your phone muted and cameras off. Are there any representatives of the news media on Zoom? Raise your hand if there are. Okay. All right. Recognizing that there is no news media in attendance, the public will be moved into a separate breakout room for the duration of the executive session. We will return to open session before taking any final action or making any final decisions. It is estimated that the board will return to public session at
probably 45 minutes.
So we will be back to public session at 2:00 p.m. Please be aware that it is possible that the board's executive session may last longer than 2 p.m. If the public has any questions about whether the board is still in executive session, then the public can contact Carrie Edwards at Carrie, CARRIE.Edwards@oha.oregon.gov. We are now in executive session. The Board of Sign Language Interpreters will now exit the executive session and reconvene open session at 26 p.m. No final decisions were made and no votes were taken in executive session. The public will be moved back from the breakout room. And representatives of the media may once again report on all board discussions and actions. Okay, so Sammy, how do you recommend that we proceed with the time that we have left? Should we address public comments and then hear public comments, and then with the time that we have remaining, do board actions, or do you see just the opposite?
That's fine. Yeah, you can do it as the chair, yes. He can do comments first, I think. There's a lot of people in the room, so I would say yes.
Okay. All right. I think we'll, does everybody feel comfortable with that to allow the public to make a comment first? So we'll go ahead to that. Or is there? Okay, are there any public comments? Who's the first person that we have?
He needs to read us into.
Oh, yeah. On the sheet.
I don't see. Thank you. Sorry, I didn't have that. At this time, the Sign Language Interpreters Board will now hear public and interested parties feedback. Members of the public, please wait until you have been recognized. Once recognized, please state your name and affiliation to the board for the record. Okay, the first person we have is Melanie Delia.
Can you guys hear me okay?
Yes.
Great. Guess I could also, do you want me to have my picture up? I don't know. Just wanted to say hello. I represent Portland Community College as well as a Oregon ASL Court Certified Interpreter. I have 30 years of experience working as an interpreter in Oregon in a variety of settings. So I represent all of that when I come to the board today. I wanted to touch on what I heard earlier about what did you guys call it? The conditional license for interns. I didn't want to see it so narrowly defined. Internship can be in a variety of settings. I myself had an internship that took me to a lot of different settings, be it medical, legal, education. Currently, with Western Oregon University's development of their master's program and where they place interns as well, could change over time. I don't want to see us locked into a very narrow scope of where people with that credential can land. Additionally, I'm a hiring entity and I utilize deaf interpreters every term. I use about 4 or 5 deaf interpreters consistently, and I share that pool of very few interpreters with Clark Community College over in Vancouver. When we grow deaf interpreters for the state, we currently do not have an approved curriculum for them. So where they would find themselves as a learning or intern would not be encompassed under what you guys have narrowly defined. This causes me great concern as we do utilize deaf interpreters and kind of grow our own, because we do not have an approved curriculum for them. They're taking training out of state through RIT and online courses at this time. So I would like to see that addressed as well, and maybe more loosely defined so that we can support our deaf interpreters. Additionally, deaf interpreters don't have the volume of work as hearing interpreters. They would be what we call low incident language, and they're usually utilized in medical and legal settings, as well as now trying to grow them in post-secondary education. And the goal eventually would hopefully see them in K through 12 settings as well, because that's where we witness language deprivation, and we need deaf interpreters in that setting as well. I just like the board to address that. Thanks.
Switch. This is Jack. Thank you, Mel. Next we have Annie Galaxy or P.C. Oh, PC is public comment. Okay. Just looking at a sticky note passed on to me here. I was just following up the notes.
I'm Annie Galaxy. I'm the administrator for Lane Regional Inclusive Services at the Lane ESD in Eugene. We currently employ 26 sign language interpreters to support deaf students, staff, and parents in Lane County schools. I'm not an interpreter. I am a previous teacher for the deaf with my professional administrator license, and I'm a PhD candidate in special education at the University of Oregon with a focus on bilingual special education. I do supervise all 26 of our interpreters and recognize that I do not have the expertise in educational interpreting to provide mentorship related to practice for my interpreters. What I have done is implement systems that support the growth and development of an incredibly strong group of professionals, and I'm proud of the work that we do in Lane County. We have found that graduates from out-of-state and Oregon programs need time and opportunities for growth to achieve the required EIPA 3.5, and we are dedicated to providing this support. Students in our schools deserve highly qualified interpreters, and that requires dedication from K-12 educational institutions like ours. As the curriculum at Western has changed, we've adapted our program to match the needs of the applicants we receive. We've invested a great deal of time and resources into developing a mentorship and feedback program to support the development of early career sign language interpreters in K-12 settings. We have a professional learning team dedicated to this work. In addition to weekly mentorship meetings and goal setting, we require our interns and trainees take the EIPA at least annually to monitor progress and set new targets for growth. We have found that within 1 to 2 years, all of our trainees are proficient, dedicated to the field, and that our student learning and graduation outcomes reflect this level of quality of service. We would be happy to work with statewide regional programs to align our practices. Last year, we began offering financial scholarship or sponsorship for all of our interpreters to take the EIPA every 3 years to continue to develop their own practice. Several have taken the test and are awaiting the results. That said, many of our most skilled staff have not pursued taking the EIPA after their original passing, some as long ago as 2008. Of my 26, 2 currently meet the requirements for the temporary supervisory license. I have scrambled to schedule EIPA testing in Eugene, but even if my interpreters all take the test when we have it scheduled in February, and even if they all achieve a 4.0 on the secondary level, they won't qualify for the supervisory license for 3 years. This does not help us support interns and early career professionals. And while I appreciate that the board is on the right track, with the learning permit as motioned and passed this morning, there is still work to be done. The Interpreter Licensing Board has an opportunity to make positive change regarding the development of educational sign language interpreters in Oregon. And I encourage deep consideration of a way to support early career educational interpreters without adding additional barriers or venturing into ODE and TSPC's regulations
Can you hear us?
for educational administrators.
Yes, we
Yeah, I
have
hear you now.
3 minutes allotted for each public comment. I'm so sorry, we have to cut things short.
Oh, that was done. Thank you.
Okay, thank you. This is Jack. Okay, do we have any comment from the board? Is there any more public comment? Mel? Do you have another comment or is that one for you?
I do, and I think I have a few minutes left. I just wanted to add from yesterday's session, 'cause I didn't get to say one piece, was the piece when we work on our medical license and we work on creating this, there's an additional fear of mine when we look at fees and fines to public entities like medical clinics, small offices, attorney offices, so forth, that threat of a fine, my fear is they will stop serving deaf people. If they cannot find a licensed interpreter, they might turn away deaf patients and deaf people in need. And how we can, when we roll this out more thoroughly, how we make sure that doesn't happen, that, that this is a process that brings people in and doesn't push people out, because we already are in a shortage, and this gap time could be a really long period of time, and deaf people, every encounter they have is critical for them. So that 1 or 2 times they get turned away can have really high impacts on their livelihood and their health and well-being.
Thank you. Anything else?
Maybe. We've got 2 comments in writing. It's,
All right,
we
go
have
ahead.
to put them in the record. At the end of the meeting, we take any paper that we received and put it into the record for the world to see later.
Okay, and I would like to have to make my statement.
So I'll put these in the record unless somebody wants to read their own statement in from comments.
Colleen? Colleen said I can read the statement. Sacramont said no, but you can file. For the sake of time, we'll file those 2 comments at the end. Okay, I will keep this brief. I have a script here that I wrote. Taking off my board hat and putting on my hat as, can you come a little closer to me? Thank you. Great. Now I'm switching hats, coming to you as the president of the Oregon Association of the Deaf. I'm compelled to address the concerns raised by some interpreters about the potential impact of House Bill 2696. While I acknowledge your apprehensions, I must highlight a broader, more pressing issue: the ongoing challenges faced by the deaf community, not only in Oregon, but nationwide. The reality is
the deaf community does not enjoy the same abundance of employment opportunities that you as interpreters do. Many deaf individuals grapple with finding or holding jobs primarily due to the lack of accessibility and accommodation in the workplace. This disparity is not a mere inconvenience. It is a significant barrier to our community's ability to thrive. It is important to remember that the field of interpreting exists largely because of the deaf community and the protections afforded by the Americans with Disabilities Act. Our community's needs have directly contributed to the growth and necessity of your profession. Therefore, I urge you to consider the broader context of your concerns. As interpreters, you play a crucial role in bridging the communication gap between the deaf and hearing worlds. This role comes with the responsibility to advocate for and support the very community that relies on your services. I call upon you to stand with us, not as service providers, but as allies in our ongoing struggle for equality and accessibility. The enactment of House Bill 2696 should not be seen as a threat to your profession, but as an opportunity to realign your priorities and reaffirm your commitment to the deaf community. I ask you to reflect on the fundamental purpose of your work and join us in our efforts to create a more inclusive and equitable society. Let us work together to ensure that the needs of the deaf community are not overshadowed by professional concerns, but instead are recognized as the core of what makes your work so vital. Thank you.
Thank you. So we'll close public comment. Oh, yes, Sammy.
Because we read yesterday's public comment, we probably should read today's for fairness, but in the future, unless the chair's against it, if you want to make comment verbally or in person, we won't read them, we'll put it in the record. That's a lot to read from Bob. Colleen, can you? Thank you. So this one starts here, and then ends on that. Actually starts here. And then yeah, so that part, this part, and then this next. But yeah.
Oh, I didn't have a response. So this is just from her. The 3 different emails. Yeah. I would like to remain anonymous. And this first comment will be translated into ASL as well. But I'd like to remain anonymous due to fear of potential retaliation by board members. I'm writing this because I'm concerned about one member of the board, Mish, Katie, sorry, Mish. In a recent email, misstated the following recommendation to interpreters. And I quote, "I've been getting questions from DIs who are still working on getting a credential. The quickest route to licensure is getting an ASLPI 4 or an SLPI advanced score and applying for the provisional license. Until then, I recommend using the label cultural broker or language specialist and continue to work. DIs are incredibly valuable and necessary. So please don't let licensure stop you from working and earning your fair pay." With 2 exclamation points. "We need you," exclamation point, end quote. This statement is a recommendation for professionals who are working and performing the duties of an interpreter as defined by House Bill 2696, Section 1, subsection 2, subsection 3. Number 2, quote, "Sign language interpretation services means the interpretation of conversations and other communications by use of a visual sign language." 3, sign language interpreter means an individual who provides sign language interpretation services. Next paragraph. Mish's recommendation to continue doing the work of a deaf, quote, "deaf interpreter," but titling oneself as a, quote, "cultural broker," or titling oneself as a cultural broker or language specialist is a direct violation of the law and its intent. The function of this law is to prevent those unqualified from providing interpreting services by specifically defining the roles and scope of an interpreter's work. What is preventing anyone, hearing interpreters or deaf interpreters, who decided they are self-qualified, from donning the title of, quote, "cultural broker" or language specialist, despite no state recognition or license, and still performing the duties of an interpreter as defined by House Bill for the Interpreter 2696. I don't believe it fitting for a member of the board to intentionally advise people to circumvent the law as written and intended, and I believe that the other board members should consider the implications of having someone on the board who advises members of the interpreting community to directly violate the law. Further, Mish is also a prominent educator in the Portland interpreting community, which concerns me greatly. Section 21 states that an individual may have their license revoked, suspended, or denied for various reasons. I believe Mish's actions promoted the use of a false label in bold or other representation also bolded, and that was unprofessional conduct as established and violates subsection 2B and J, which is quoted below. So B states, using, causing, or promoting the use of any advertising matter, promotional literature, testimonial, guarantee, warranty, label, insignia, or any other representation, however disseminated or published, that is false, misleading, or deceptive. J reads, unprofessional conduct, negligence, incompetence, repeated violations, or any departure from or failure to conform to standards of practice in performing services or practicing in a regulated occupation or profession, subject to the authority of the boards councils, and programs listed under ORS 676.565. That is the end of testimony 1. Public comment 1. Second public comment being read starts here, I believe. And then do I read the name or do I leave that out? Are we keeping this anonymous?
If they didn't request to be kept
Jackson, if they didn't
anonymous,
request to be
it's
anonymous, then you would say the name. Yep. Is that correct? Okay. So Caitlin Holden. Says, hi Carrie, I wanted to add my public comment for today's board meeting. Is there a time frame for permanent rules being established before the temporary licenses expire? With the current results from EIPA or RID taking 6 months or more, how can we be prepared to have the qualifications when licenses will be enforced? It continues. Following up, rural, from the same person, Caitlin Holden. Rural community in Central Oregon has 2 supervisory licensees. 1 freelance interpreter, 1 full-time interpreter coordinator. I know that some rural districts are not following the EIPA requirements by hiring those that do not have a 3.5 by changing the title from interpreter to ASL facilitator or paraprofessional. That's the nature of rural interpreting. And then above that was the last comment. It says, last comment I'd like to add, I'm unable to make the comment myself because of my Wi-Fi connection and background noise from where I'm currently located. So please read my comment. I am still in the meeting. I'm just unable to make this comment for myself at this time. Thank you so much. Signed, Caitlin Holden.
Thank you so much, Colleen, for signing that. Oh, absolutely. It's fine, it's fine. Okay, is it safe for me to close public comment? Okay, great. How do you suggest I proceed with the 8 minutes left that we have, or do we request a 15-minute extension?
Yes, we have 2 agenda items that we need to get to.
Okay, then, so we can extend it to end at 3:15, is that okay with you?
Do we have cart
The
services?
cart services, she might leave. Will there be anybody that needs cart?
We're currently assessing whether or not interpreters and CART are still available. Can we switch over to Zoom auto captions if CART can't stay past 3?
As long as everyone feels that that is okay for them.
So the
Anyone
CART
says-
provider is. Jack is saying, I'm comfortable with that because we already have some English interpreters in person. I'll say, well, would CART services be for the audience? Jack is saying, well, we can turn on Zoom captions and then we also have live interpreters on video and in person. Thumbs up from across the room. Carrie has her hand up.
So the cart provider said she can stay for the 15 minutes.
Oh, excellent.
Perfect, great. She wanted it around the room. Thank you so much for arranging that, working it out, Carrie. Okay, great. So let's get going with the time that we have, which is limited. So what should we do first with the 2 agenda items that we have, which is a priority?
We'll just look at the rule schedule, which Bob has that for me. And then you guys can recommend RAC membership.
Okay, let's go ahead and discuss the rule schedule.
Okay, so as you know, we're under a pretty tight timeline, and rulemaking can be shorter or longer, but really depending on how many rules advisory committees you want to have, things like that. So I scheduled 2. So directly after this meeting, I'll start putting the word out, the letter and the interest forms, having people apply to be on the Rules Advisory Committee. Rules Advisory Committee will be February 15th, February 29th in this room. We'll have preferably in person, but we can make some accommodations. The board will meet on March 20th,
These are going for
Interpreter
February.
clarification,
February 15th,
February 15th,
February 29th.
and February 29th.
Both. And then March 20th, the board will approve proposed rules. They'll look at what the RAC did, their recommendations, make any changes, approve proposed rules, and then I will file with Secretary of State. You'll also give me feedback on fiscal impact, small bits, any impact on small business, consumers, government, and I'll have all that stuff scripted for you, so you just give me information. Then I'll file a rulemaking notice for Secretary of State. It has 28 days for public comment, so April 1st to April 28th. I have scheduled a public hearing for April 18th in this room. You can also do it online, so we'll have a Zoom link.
The 20th, clarifying the dates.
18th,
18th, April 18th.
April 18th.
April 18th.
And there'll be a Zoom link. Or you can hear, either one you want to do. Then the board will meet again on May 15th. You'll have all the public comment, you'll have hearings officer reports, you'll have the new draft rules as it usually depends on if there's like little tweaks, like change a word or a comment that I can make, I will do that, and then the rest, we pretty much leave any technical stuff up to you guys. Then you guys hopefully adopt permanent rules, and then they will be filed with Secretary of State and adopted and effective June 7th.
Eric has his hand raised.
Just to clarify, for the RAC meetings, did you say those would be accessible via Zoom too? Online or just in person?
You preferably the RAC members in person, just because it's like this, but it's more dialogue, it's more back and forth, back and forth, back and forth.
My only concern is it might create some barriers for rural folks to get here to participate.
I mean, we can make accommodations. Prefer, but I have done many RACs
And
online.
the weather.
Yeah.
And we do travel reimbursement.
And we do travel reimbursements.
Actually, yes, I also want to make that comment about rural interpreters, but also the deaf community. There's a lot of diversity within the deaf community. Some people are not able to afford to be able to come in person. Some people are able to come in person. So I think having a hybrid system would be more accessible to the deaf community as well. We'd like to include more community members who are deaf on the rack. Mission signing, can we say 60% deaf on the rack or? I'm not sure if this is the right place to say that, but I would say yes. I think 60 is maybe too much. 51%, you know, it's like the board of trustees, I got it, and they say there needs to be a minimum percentage. I think 51% seems good to me. We can strive to have 100% deaf. It might be hard to do, just depending on who we're looking for. If we want, 8 members on the rack, maybe a little bit more challenging. 4 people is much more doable, just depends on the amount of people on that advisory committee, but I agree, it should be at least 51%. That's the right word. Highly encouraged, 51% deaf.
So do you have any specific criteria for, you can break up the 51% or the 100%? Do you want 30 representative indigenous communities, low income communities, rural communities?
I think bottom line is just 51% deaf, 49% hearing. In terms of identity, we need to have diversity in regards to race, so that would need to be balanced. I would trust your decision in that. Well, it's not mine, but I'm not sure. But anyone else want to share what they feel and what they think we should add. I mean, I'm a white man. I don't know if that's necessarily my place to make that determination or make a recommendation for that. I could just say that I believe it should be 51% deaf and 49% hearing, at least. This may be conflicting with your comment. Yes, I understand your statement about having a minimum percentage that are deaf. But if we're looking at it from an interpreting perspective, whether or not hearing or deaf, do the deaf individuals who are not interpreters understand the process of what it takes and duties involved in being an interpreter, such as the code of professional conduct, our code of ethics, our duties, and so forth? If we have an individual part of the board, I feel like we're going to spend a lot of time educating that individual, just as we spend a lot of time here educating individuals about our profession. I think they should be active interpreting professionals rather than receivers of services. So that's my feelings on it. I'm just trying to figure out that from like a state board perspective, when we have a CDI and a DI, that's already such a small number of people, and they typically have their days full. I don't know if they would be willing to give their time. So if we have a minimum of 51% of deaf people who are receiving services who aren't interpreters, I feel conflicted about that. Sorry. Colleen, thank you for your comment, and I acknowledge what you say. Thank you for that clarification. Yes, I do realize you are correct. We need to be more specific as to what the definition is of a deaf person on the rack. So maybe a percentage of consumers and a percentage of interpreters. We're going to have to define that somehow. Al is walking up. Hi, this is Al. I wanted to respond to both Jack and Colleen's comments. I agree, it needs to be diverse. I see where you're coming from, Colleen, where you need to have somebody who's informed about the process of interpreting on the board or on the rack, as well as having a diverse group of people with their lived experiences. So I do think there needs to be a balance in that way. Another thing to add to clarify that just came to mind and was mentioned is that it's really important that if there's a hearing interpreter or just an interpreter in general, is that BIPOC individuals have more barriers navigating the systems. So it's vital that we include them in that. We don't want to create additional barriers or reduce the number of BIPOC interpreters. We want to grow that. The deaf community has diversity, so we need to have a reflection of that community, both interpreters and on the rack.
Do you think it's important to have like an educator, a higher ed, K through 12, somebody who works with courts maybe, somebody who's on the registry, just ideas, somebody who's rural.
Audrey? So this is the first list of ideas that I have for positions on the rack. I have 3 interpreters for each type of license we're developing. So a medical interpreter, a legal interpreter, and an educational interpreter. 1 IEP instructor, maybe 2 at least, from both PCC and Western Oregon University present. And of course, deaf community members, consumers, users of services. 1 certified deaf interpreter. 1 representative from a hiring agency, and geographically diverse as well. So I don't know how many divisions there are or regions there are. Colleen was making a comment. A VRI, video remote interpreting. Right, so somebody who specializes full-time in video remote interpreting work. I mean, we could include all three as well, but those were my initial ideas. Oh, and to have a trilingual interpreter represented on the rack as well. It doesn't need to be specific about the third language that they interpret, but at least a trilingual interpreter that has 3 languages that they work between. It doesn't have to be Spanish, that's the most common, it could just be an additional language. Jackie said, any additional comments from the board, from the room? Okay, so what do I do with this? I have to approve this schedule?
Yeah, you can take a vote to approve the schedule. Yeah.
Okay,
You guys are okay.
can someone make a motion to approve the schedule? Mitch says, I motion. Did you make a motion to approve the schedule? Oh, I move to approve the schedule, yes. Okay, Eric seconds that. And we can vote, Eric?
Aye.
Aye. Tammy? I'm concerned there's 2 meetings, the board won't be enough. 2 meetings with the board is not enough.
The rack, it's racks.
Interpreter clarification, the rack on the board, and saying the board.
After we get information.
After we
from
get
the rack.
information from the rack.
Yeah.
We have 2
2 days.
to finish everything.
Well, the rack, and then you have 1 day for post rules. And then we gotta go out for comment, and then you have 1 day for permit. But
That's a lot.
That's a lot. As we see today. Right, Tim says,
okay,
I don't know what to.
do you want more board meetings?
I'm just saying, can we
More
open
board meetings has to
that for
be
discussion to add additional? It's just saying, can we start with 2 and go from there?
Well, wrong timeline, right? You have to be done by June 7th.
It's just, I prefer to try. I say, okay, well, we'll proceed with the votes and then we can ask about that. Tammy abstains. Okay, that's fine. Mish? Aye. Audrey? Aye. I missed it. Colleen? Abstains. Abstains. Al? Aye. Jack? I abstain. Mish says the motion pass. Yes, the motion carries. Actually, wait, was that the majority? Or was it 3 abstains and 4 in favor?
Yes. Yeah, that's okay. If 4 voted yes, that would pass.
Okay, the motion carries. Any questions about this? Or on? I do want to ask, since this has already been approved for the next meeting, can we, if you realize that we need to make a slight addition or an adjustment, would we be able to do so?
Say that again.
Sure, so let's say at the next meeting, we realize that we do need an additional meeting. Even though the timeline has already been set until June 7th, are we able to add meetings? Let's say we've got like February 15th, can we add on the 17th? Is that a possibility? We needed to add on additional meetings.
I don't know. I'd have to look at the calendar.
Okay, Colleen? Colleen here. How many of you are staff on salary? How many of you are freelance? I feel like this is already a burden to ask for more and more time from us for volunteering. I am hesitant to that. I looked at the schedule, I haven't made a proposal, but I want to make a suggestion that for those days that are already booked and reserved, can we just extend the time into the evening? That's fine, we can get interpreters for that, but not end at 3 o'clock, that is ridiculously short. We can end well past the time that regular business hours are over, and we can meet somewhere else if necessary, but I just want to extend the time so we can get everything finished as needed. And Jack's saying, and extend accommodations. Colleen is repeating that, so also extending accommodations, so that we do not need to schedule additional meetings. We can prevent that because that's an undue burden on many of us who are self-employed contractors. We don't have vacation time. We don't have PTO for this.
As long as we notice for it, yeah. So, we have 15-hour meetings.
Okay, this is Jack. With Colleen's, yes.
Oh, yes, as long as we know that we're gonna go longer, we can have the accommodations and then
Colleen's saying yes. Thank you. Jack, okay, great.
But I could, so the next item on the agenda is to approve the meeting dates, which include these dates. Well, yeah, you actually will do the other dates at the end of the year as well here. But I was thinking that you could potentially, well, never mind, we're just gonna extend. Yeah. So,
Okay, so this is Jack. Do we need to do another motion to approve the dates? I think what we just did was.
there's just 2 additional dates, so we meet your quarterly minimum. So August 7th and October 3rd.
Oh,
August 7th and October 3rd.
okay. Tammy. This is Tammy. What happens if we have a conflict with any of the dates? Currently? Like if we'll be out of town, for example, what do we do? How many people can miss a meeting and still have a quorum?
You have to have 4.
This is Jack, right? Okay. We'll just need the majority. Okay, is there a motion to approve those last 2 dates in 2024? Does anybody? Tammy? I move to approve the additional dates with additional time. Not to be concluded at 3 o'clock, that's not happening. So continue to a minimum of 5 PM is my guess, but to add additional time. A second? Okay, Al seconds. All right, so let's go. We'll start here. Al? Aye. Colleen? Aye. Audrey? Aye. Mish? Aye. Tammy? Aye. Eric? Aye. And this is Jack, and I vote aye as well. Okay. So Mish, did you want to make a motion? And Mish says that would be under other business, so. Okay, we have 2 minutes for other business. We can open for. Go ahead. Hello, this is Mish. I feel important to respond to Mel's comment about deaf interpreters. And we did start discussing about deaf interpreters this morning, and then it kind of moved over to a big discussion about educational interpreters. We want to remember that all the deaf interpreters out there are working cannot currently get a license, but they provide a very important service. So I move to add to the temporary rule, again, that will be concluding on June 8th, temporary rule that would be an exemption. So the exemption would be for a situation where a cultural and linguistic broker is recommended or requested to communicate with a consumer of a more marginalized culture, or who uses a foreign sign language, idiomatic language, non-standard language, or dialect, visual gestural communication, or home signs. That's my motion. This is Jen. Okay, I'll second. There's Tammy says there's some discussion.
So this is Heather, just to clarify, what you're proposing is an extenuating circumstances rule for what you had just described, where it would mean that if they fulfill those circumstances, they don't need any type of licensure. And that would be a temporary rule that would extend for until the new licensing, permanent licensing. Can you describe for me again the need and the services that are not being fulfilled?
This is related to Mel's comment. So Mel mentioned that at PCC, there are deaf interpreters, a few every term that are employed. And again, that would be like starting Monday. So for example, most often, I hope I remember this correctly, but most often at PCC, it would be, for example, a deaf student at the college who is from another country, has recently moved to the United States, or they use some type of visual communication, but they really don't have typical ASL skills, or they don't know ASL as a language. So in that case, they will have a deaf interpreter who is working as a team with a hearing interpreter, and for cultural reasons and linguistic reasons, they are expert to help in that situation and be the team interpreter. So there's a small group of deaf interpreters that we call brokers that are not qualified under the law currently to be licensed. And so they're not able to apply to become licensed, but the community still needs those deaf interpreters. So there's a gap there. Jack says, go ahead, Audrey. Audrey, Mish, and I'm asking Mish, but also Mel too, I guess, why are they not allowed to apply for licensing? They would have a qualified interpreter with them, right? So wouldn't they be able to apply to be for that learning permit that we just talked about? We didn't use the word intern in that, we used the word learning permit, right? Did we? I don't know why they couldn't apply under that permit that we just set up. Jackson's, Colleen, go ahead. Audrey, your suggestion, I like that idea that they could be, under. Mish says, oh, I know why that doesn't work, but go ahead, Colleen. No, you come on, Mish. We need both here. This is Mish. In response to Andre, I just realized, because it's set up as a specialist license and it wouldn't be medical and legal. So deaf interpreters or deaf brokers are working in medical and legal settings currently as well, and that's very important too. So not just in PCC or a college situation. Mish, this is Colleen. I can agree to disagree. I think some PIs are not ready for legal settings. So I do think that that's where they, would need to work on training and proficiency, starting with this temporary license and get training, then, would be more ready to do legal and medical, but to just throw people in right now. And Mish is saying in this 6-month period, I'm talking about just limited to the 6-month period. And Mish says, well, maybe the permanent rules would be different, but Colleen's saying, I think I don't mind considering a DI to be, under someone else's supervision temporarily under somebody who has a supervisory license, but I think the liability of, not knowing the roles and the boundaries and not having the proper training. So for a DI, a deaf interpreter to go into a legal setting, it would be high risk. So I don't want to start a situation where that could happen. Jack says, any additional comments? Should we move ahead to
So I
vote?
believe that motion was made. So then you would ask for a second. If there's no second, then there's no need to take a vote.
Al already seconded.
So Al seconded, then you need to take a vote.
Well, can someone say the motion again?
Yes.
Because I'm not sure.
Okay. Go ahead, Mitch. Okay, so I move to add to the temporary rules an exemption that says for situations in which a cultural or linguistic broker is recommended or requested to communicate with consumers who are from marginalized cultures or consumers who use foreign sign languages, idiomatic language, non-standard dialects, or visual gestural communication or home signs. This is Jack, okay. We'll go ahead and vote. Al? I'm abstaining. Colleen says I abstain. Audrey says nay. Mish says aye. Tammy? Tammy, I abstain. Eric, aye, but it's not. This is Jack, and I will abstain.
Motion doesn't pass.
So
That was only three, your motion does not carry. So it's two. The motion. Then defeated, and Colleen? Oh. Okay. I'd like to make a motion, I'll come over here. I know we're best friends, yes, I know, Jack, I got it. This is Colleen, I was thinking about, I'd like to make a motion, I know it's not perfect, but it seems to satisfy the concern of DI interpreters at PCC Community College. I feel that that could be considered under the learning permit for 6 months to be working in those circumstances. So I would make a motion that what Mish said to be under the learning permit, or what do they call it? Learning permit under the temporary license. So deaf interpreters to provide those with atypical language and oh, no.
Heather, this is Heather. So I'm just going to clarify the language that you had adopted earlier would be that a person who can work with direct on-site supervision for the purposes of learning, but not in a medical setting, not in a legal setting, and they can't provide services in an educational. Just want to remind you. That's what you'd already approved.
Yep.
Jackson, okay, so that means that seems like it's already, I mean, it's kind of out of order. It's already, they're saying that's out of order then to make a motion since it's already included.
it's okay to make a motion to include that. I just want to make sure you are all aware of the settings that you had already decided. You would not be changing the settings unless you made a different motion to change the settings.
Colleen says, okay, that's good then. Yeah, and Mish says I rest. Says, okay, all right, we're, go ahead. Should we go ahead and move? Wait, a motion for what? I thought Jack says, oh, do we not need the motion now? Okay, no motion then. All right, no motion. Okay, motion dismissed then. Okay, are there any other comments or any other board business? I don't see any, so I would assume that we will adjourn the meeting at 3:25.
Thank you, board members. I don't like you.
It's okay. I don't like you either.
So I'm trying to keep a lot of because we all the time. Is it your license? Right. You worked tonight. And I want to talk to you. Let's see. Well, there's 2 in 1 and 1 in another. Yeah. The one.